The Florida divorce court process from start to finish. While most of my previous articles describe how Florida law is applied in a divorce case, it is very difficult to describe accurately how the law is applied and when. The actual Florida Family Law Rules of Civil Procedure are 175 pages long and presume a great familiarity with both the underlying law and the rules of evidence. Here, I outline the entire Florida divorce court process in summary. Divorce versus parentage cases. Married people can get divorced and unwind their relationship as to both their assets, debts, alimony, and, if there are children, support and issues relating to parenting time. If non-married people had children together, they use the same set of Florida family laws and procedures as married people do. Non-married people, however, can only use these laws for determining parenting time and child support. Both types of cases start with a pleading requesting relief. A pleading is essentially a letter to the court asking the court to do something. Can I file my family law case in Florida? You can only file your family law case in Florida if you have lived in Florida for 6 months. If you have traveled outside of Florida during those 6 months, the law looks to your intent. If you were traveling on business or you were on vacation, you are deemed to still be living in Florida for period that time. If you have children, you can only handle the child-related aspects of your divorce in Florida in the county where the children have lived for the last 6 months. Service. Florida describes the two parties to a family law matter as the petitioner and the respondent. After a case is filed, the respondent must be served or they may file their own appearance in the case which waives service. Service is the formal notice of the lawsuit whereby a process server presents the respondent with notice that they are a party to the lawsuit. Typically, a licensed process service company is hired by the petitioner, but the court can appoint any non-interested person to serve the respondent. When the process server has served the respondent, the process server fills out an affidavit of service and the petitioner's attorney files that affidavit of service with the court. If the respondent agrees to waive service, they have 60 days to formally reply to the divorce or parentage petition. What if you can't serve the respondent? If you have no idea where the respondent lives, works, or simply is, you must file an affidavit of diligent search and inquiry where you must testify that. Upon filing an affidavit of diligent search and inquiry, you can publish notice of your divorce or family law case in the local newspaper. This is called service by publication. Service by publication will allow you to divorce and even give you custody of the children, but all other issues are reserved until the respondent is eventually served or files their appearance. What happens if the respondent does not answer the petition after being served? If the respondent has been served and they do not file anything with the court indicating that they will be part of the process after 20 days, the respondent can be defaulted. A default divorce or parentage action means the petitioner gets to enter final orders as they see fit, within reason and supervision of the court, based on what they asked for in the pleading which was served. How do I answer a divorce or family law pleading? A pleading is a list of claims or alleged facts. The answer has to admit, deny, or claim insufficient knowledge of each particular claim. If you don't answer a claim, you effectively admit to that claim. While answering a claim, you can also file your own pleadings under the same case. What can I ask for in my divorce or parentage pleading? If you are requesting a divorce, you can ask the court to award you a division of the marital assets and debts, an award of alimony, a parenting schedule, and child support. If you are filing a parentage action, you can only ask the court to enter a parenting schedule and an award of child support. What must be done before the court decides on the pleadings? Most parties come to an agreement on all matters through mediation and negotiation. Until that moment of agreement, there are certain requirements the courts put upon both parties to comply with what's called discovery. Both parties must fill out and file a financial affidavit. The financial affidavit is a form that all family law petitioners and respondents must fill out, detailing broadly their assets, debts, and income. Personal information such as social security numbers, account numbers, and even email addresses are not to be included in this public filing. The financial affidavit is filed publicly, but all other financial documents are merely exchanged between the parties. Can I ask the court for temporary help before the trial? Yes. There are numerous things the court can be asked for during the pendency of your divorce or parentage action, such as temporary child support, temporary alimony, or temporary parenting time. How are my kids considered in a divorce? While all the discovery matters discussed have dealt with financial issues, the children themselves may be subject to investigation to determine parenting time and custody issues. A child evaluator is an expert, usually a psychologist, appointed by the court to interview the children and issue a report on what they believe will be in the best interests of the child. Alternatively, a social investigator may be appointed by the court. A social investigator serves the same purposes as a child evaluator, except their responsibilities are much more in-depth. They will not only issue a report regarding the best interests of the children, they will also craft parenting plans. These reports and the testimony of the child evaluator or social investigator may be used by the courts in determining both temporary and final parenting time and parenting responsibilities. Case Management Conference. While all the discovery and temporary motions are getting resolved, the court is likely to order a big meeting between the attorneys to get everything in the case organized. This meeting is called a case management conference. At a case management conference, the court will set time limits to get various things done. Pretrial. Before a divorce trial happens, a pretrial will be set by the court. A pretrial will narrow down the issues of the case and establish exactly what the agreed facts are via a stipulation of facts or an admission of facts. A pretrial allows a last-chance amendment to any pleadings based on facts that were discovered since the filing of the original pleadings. The trial. Hardly any divorce or parentage action actually goes to trial. Mediation and negotiation resolve many if not most issues. Typically, the parties have each proposed final documents to the court if the judge requests them. The parties will have agreed to a stipulation of facts, in which they have signed off on a list of the facts upon which both parties do agree. All issues will have been narrowed down at the pre-trial a few months prior, so there will be no surprises at trial. Trials are conducted according to the rules of evidence. The rules of evidence are a Byzantine set of rules all civil lawyers use to enter evidence into the court for the court to consider. Evidence can be testimony or evidence can be physical objects like documents. If you'd like to learn more about the Florida divorce process, contact my Naples, Florida family law firm for a free consultation with an experienced Florida divorce attorney.